Good morning, everybody, and welcome to Public Administrators 101. Today, we are joined by Carol Johnson, Cher Caudell, Karen Dye Allen, and Steve Farmer. Carol has been the Dallas County Public Administrator since 2009.
Audio.
What? Can you hear me? Okay, Carol has been the Dallas County Public Administrator since 2009, is the current Missouri Association.
Good morning, everybody, and welcome to Public Administrators 101.
Administrators MPA President.
Today we are joined
Serves
by
as Vice President, Treasurer, Secretary, and past Legislative Committee Chair for MAPA.
Carol has been the Dallas.
Carol was also a licensed nursing home administrator for 20 years and is a lifelong native of Southwest Missouri. Cher has been the Monteau County Public Administrator since 2003. Cher was awarded the MAPA Public Administrator of the Year Award in 2019 and also currently serves as the Treasurer of the MAPA. Cher has served on the MAPA Legislative Committee since 2005 and Department of Mental Health Liaison Committee since 2006. She is a co-chair of the newly formed Standards of Practice Task Force for MAPA. Cher has also served as the Missouri Association of Counties Board District Representative since 2010, as a member of Missouri's Working Interdisciplinary Network of Guardianship Stakeholders, or MOWINGS, and a lifelong resident of Monteau County. Karen has been the Callaway County Public Administrator since 1997 after working in Jefferson City 9 years as an attorney for various state agencies. She earned her National Certified Guardian status in 2005 and was a recipient of the National Certified Guardian Excellence Award in 2016. She is a member of MOWINGS and also serves as a Regional Vice President for MAPA. Karen lives in Callaway County with her husband Eugene, a retired certified public accountant who is a brain injury survivor. Steve is in his second term as Jefferson County Public Administrator. Steve is a Southern Illinois native and retired 21-year veteran of the Navy and Navy Reserve. He is grateful for the opportunity to improve the lives of those dealing with intellectual and developmental disabilities in his community. Steve is a professional with life experience, having a doctor with myotonic dystrophy and fetal alcohol syndrome. Please join me in welcoming Carol, Cher, Karen, and Steve.
I'm going to be talking about Public Administrators 101, Guardians Today, about what we do and how we operate in the state of Missouri as public administrators. So our objectives for today, for you to understand, are to be able to explain the difference between a power of attorney, guardianship, and limited guardianship, to be able to describe the statutory responsibilities of a guardian, to identify barriers and benefits of guardianship and understand the impact of guardianship on individuals, to explain the guardianship process to someone who is considering guardianship, to discuss orders from the court and be able to identify any limitations for a guardian's authority, to describe where to refer families and individuals for information on the guardianship process. Next screen, please. So the next things that we were going to be talking about, and here's the things that we're going to be covering today in our presentation. There's 6 points in our presentation. The first is the application and the appointment process. This is legally determined. The next thing is the various roles that we fulfill. The first one is guardianship, and what guardianship does with protective oversight for the physical well-being of a person. So we're looking out for that person's well-being. The next role is conservatorship, and the last thing that we do, in addition to guardianship, multiple agents, departments, and other stakeholders who are interested in what we do as guardians and conservators, and that we do that we can have a full and comprehensive team to provide protective oversight for the rights and the well-being of people who are their assets when no one else is available. And that is our primary function. So next screen, please. Would be the history of guardianship, and that would be Karen Allen.
Okay, we'll try some terms. The first term that you should know is what a guardian is, and that's a person appointed by the probate court to have the custody of a minor or an incapacitated person. A limited guardian is a guardian whose powers have been limited by the court to certain specific tasks. An a ward is a minor or incapacitated person for whom a guardian or limited guardian has been appointed. Next slide. The next one is incapacitated person, and that's someone who's unable to provide for their basic need of food, shelter, clothing, and safety such that significant harm is likely to occur. A partially incapacitated person is someone who lacks some but not all of the abilities needed to provide for himself with the same basic needs for food, clothing, shelter, and other essential care. And a disabled person is someone who lacks the capacity to manage their finances. In each of these, the person should have a physical, mental, or cognitive condition that limits their ability to provide for themselves physically or financially. Since we've defined the terms, we will now discuss the guardianship process. Next slide. While no two cases are the same, most will proceed through the following steps. The first step, when you think someone needs a guardian, you should take that person to the doctor or a mental health professional. The exam or assessment will determine the level of the person's capacity or incapacity and the level of care that that person requires because of their incapacity. Once a professional has determined the person is incapacitated or partially incapacitated, an attorney needs to be retained to file a petition with the probate court. Next slide. Upon the filing, the court will then appoint an attorney for the person. And I want to point out that our slide in this is actually incorrect because the attorney is not a guardian ad litem. Rather, the attorney appointed for the person is to assist the person in relaying their desires to the court if they are capable of expressing their desire. The court will also set the case for a hearing, and then during the hearing, evidence and testimony will be presented, and the alleged incapacitated person will also have the opportunity to provide evidence and testimony. The judge then will review the evidence and facts and make a determination. If the judge concludes that the person is incapacitated, then he will need to decide who the guardian will be. And if there's no one that is willing or able to serve, then the judge can appoint the public administrator as a guardian. Steve will now talk more about appointments.
Thank you, Cher. So in the appointment process, initially, the appointment process is usually temporary, although this varies from county to county. After 30 days, there is then a permanency hearing. This provides further court review of the case before a lasting determination or a permanent determination is made in the case. That is to allow for more information gathering, for us to contact relatives and identify relatives, to discover assets and any liabilities in the estate, to find personal or real property, and any other things that are pertinent to the case, again, before we go to permanency, because it is possible that we could go to that permanency hearing and there could be a determination that we do not need to be permanently the guardian or the conservator, and that someone else can be appointed or that person can be restored. Most counties, though, appoint guardian conservatorship at the hearing based on the evidence and the testimonies of presented on that day. Next, thank you. A guardian is someone who is appointed by the probate court to have the care and custody of an incapacitated person. The guardian provides periodic reports to the court on the well-being and status of the ward, how they're doing, to the court, and that is generally done on an annual basis unless the court orders us to make an additional report for some reason. We also seek additional orders from the court as needed to administer the estate according to the particular circumstances of the ward. So there are some circumstances that would require us to go back to the court and seek specific orders to give us additional authority if we have to deal with other entities or businesses or agencies to make sure that we can properly do our jobs. It is also very important to understand that the guardian has no authority until it is granted by the probate judge. And that is something that a lot of people don't understand. We do not have any authority until it is granted to us by the courts. So it's important that you are aware of other resources that are available. For example, the Department of Health and Senior Services has a hotline for people who you may suspect are being subjected to abuse or threat, or they are endangered, and you can contact them for anybody who is an immediate risk, and they have authority to go out and do a comfort check on people and to check on their status and see if they do need a guardian. And then the number for that hotline is 800-392-0210. Next slide, please. So who may serve as a guardian? And anybody who's an interested person may petition to become the guardian of an individual who is alleged or suspected to be incapacitated, in other words, unable to make their own decisions. And if so appointed by a judge, they may serve in that capacity. An interested person may also petition for the guardianship and request that someone else be put in place or appointed as the guardian. The law states that the court shall consider the appointment of a spouse, a parent, adult child, an adult sibling, brother or sister, or other close adult relative of an incapacitated person before considering the appointment of a non-relative. It's the family priority preference, and this is not obligatory because the appointment is based on what's in the best interest of that person. But it is generally a good idea to put somebody in place who knows that person, and that would be a family member. Next slide, please. So a family member, here are the pros and cons of appointing a family member. They're more likely to be aware of that person's needs and desires, as well as any natural support that they would have from family, friends, and from the area where they live. And then also they have a more personal investment in that person and would have more insight into what is important to that individual if they're unable to communicate with people in general. So they're going to have a better understanding of that person's wants and needs. And that's why it's most important to have a family member if they're willing and able to serve. The cons are that they might have a harder time making difficult decisions that are in the individual's best interest, but it's something that they really don't want. And that's something that even parents, understand, that sometimes they have to do what's in the best interest of their child. So it is the same with someone who is a power of attorney over someone, and you have to make tough decisions and tough calls for them based on the knowledge that you have. And so that might be difficult sometimes for people who are too close to that person. They also might have a lack of knowledge about resources that would otherwise be available and would enhance the quality of life for that individual, as well as making sure that they are safe. That is ultimately our biggest responsibility, and the thing that we focus on the most is keeping people safe and making sure that they are protected and their assets are protected. I'm not sure if Karen available, because she would be the next person to talk about the next slide.
Hi, Steve. Here I am. Okay, I'm going to talk about the pros and cons of having a public administrator serve as a guardian. First of all, the public administrator is an objective party. We're appointed by the court. We don't typically seek appointment. It is the judge's decision and the judge's discretion. And so we are an objective decision maker. We usually have knowledge of resources and services that families might not be aware of. Some families prefer the public administrator to be the guardian because then they can just be the family member. And I don't want to say just, because that's a very important role, but when someone else is making the tough decisions, the family member can step back into that family member relationship. And finally, another pro of having the public administrator serve is that it's an unbiased neutral party. So when you have multiple family members that may not agree on issues, again, that takes away that dissension or that possibility of disagreement, and it makes it easier for the family to enjoy being family members. So what are the cons to having a public administrator as a guardian? Well, they might not know the person as well as a family member might. A public administrator is a public guardian. We're appointed by the court and we serve a number of people. And the family would have known this individual all their lives and would know better what the person would want and what their desires, needs, and wants are. A public administrator carries a caseload. They vary throughout the state, but most all public administrators carry a large caseload with very little help. So it's much better for someone to have a family member guardian, if possible, because then they will get more time and attention from their guardian. If it's a family member has one person they're guardian for, that's a lot different than a public administrator juggling a number of individuals on their caseload. And finally, the cons to the public administrator serving. We always request that the public administrator be the last resort. We want to make sure that we use those resources for the individuals who need it the most and who don't have anyone to serve. Now, once someone has a guardian, that doesn't mean they'll always have a guardian. There are ways for the guardianship to change or to end. The probate court that establishes the guardianship can be changed. If something changes with the individual, they may improve and not need a guardian, in which case they could be restored by the court. That would mean the court would issue an order saying a guardianship is no longer needed. The individual might regain some abilities, and in that case, they might have some partial restoration. They might move to a limited guardianship or a limited conservatorship. And always keep in mind, a guardianship is about the person and conservatorship is about their money. If an individual gets worse, say they get a limited guardian, they might move up to a full guardianship. And finally, a guardianship always ends when a person passes. The authority of the guardian ends at that point, and then at that point, any family members would make decisions regarding that individual. In Missouri, we have laws that relate to guardianship. The guardian should assure the individual lives in the best and least restrictive setting reasonably available. I'm going to talk some more about what that means. What is the least restrictive alternative? The guardian should make sure the guardian gets medical care and any services they need. They should promote and protect the care, comfort, safety, health, and welfare of the individual. And most importantly, they should provide consents for that person. A guardian should carry out all the duties necessary or proper to make sure all the other things that we just talked about are carried out. Now, when we talk about the least restrictive alternative, that's an important term to know. It means a course of action that lets an individual live, learn, and work with the minimum amount of restrictions on their person. And you have to keep in mind that those restrictions are also impacted by what's reasonable and appropriate for the individual, considering their physical, mental condition and needs, and their financial status. So in other words, we have to always look at what can they afford, and also what is the safest and best place for them to live, to receive the services they need, but also to live in a setting where they can exercise as much of their own freedom as possible. So what does least restrictive alternative mean when for the guardian? And even for the team that's working with the individual. That means choosing the decision or the approach that places the least possible restriction on that person's personal liberty and exercise of their rights. And also, we want to promote the most inclusion as possible of that person into their community. Also, the decisions need to be consistent with meeting the person's requirements for health, safety, habilitation, treatment, recovery, And we need to protect the person from any abuse, neglect, or financial exploitation. And so finally, for my segment here, I want to talk about, so what happens when you get a guardian? For some people, they feel like it is a stigma. They feel like they can't make decisions anymore. And further on in this presentation, we'll be talking about some things that guardians consider, and then some things that can be considered even before you have a guardian to maybe help avoid having a guardian. Because some people do believe there's a stigma, and they feel like they're being treated differently than other people. So what legal limitations are on you when you have a guardian? Well, unless the judge allows you to continue to vote, drive, or marry, you automatically lose those abilities to do that. So you can no longer object or consent to your own medical care. You lose the right to vote unless the judge says in the original order you can vote. You lose the power to choose where you live. You can't make contracts if you have a conservator. You can't hold public office. And you can't have a driver's license unless, again, the judge allows you to do that. So the person may have little or no say about their basic decisions. And that's why we always want to work with our clients. And I think as we go forward in this presentation, we're going to talk about a team approach. And definitely the person under guardianship is always part of the team, because we never want someone to feel that they have a stigma. Even though there's some legal limitations, we want to work with them and lessen any limitation upon them. And at this point, I believe it will go back to Steve, the public administrator from Jefferson County.
Hi, it looks like I'm back on. Talk about the substitute judgment standard. So in an effort to promote the underlying values of each person and their ability to have self-determination, and also to protect their well-being, the public administrator may apply what is called as the substitute judgment model for decision-making. And what that means is that in substitute judgment standard, it requires that a decision is made by the guardian based on what they believe it is, what is in the ward would want, what their preference would be, based on what they have previously expressed, either through a will or some other document, or from what they have told friends or family would be what they want, what they like, and what their preference would be for their life. So it is very important that when we step into those substitute decision-making shoes, that we use that substitute judgment standard. We're not making that judgment or that decision based on what we would want. We're making it based on what we think or we know to the best of our ability is the preference for that person. Next screen, please. The other thing that we do is we apply what is called the best interest standard. And that is what is in the public administrator's charges, to use that best interest standard to make an independent decision on behalf of the person based on what is in their best interest, not in anyone else's interest, but on the best interest of that person. That is an ethical requirement that people who care for others will do that in good faith, placing their assessment of what that person's best interest is above their own. It's very important to understand that and to know that that is what we are charged with doing and what we will do to the best of our ability. Next, thank you. Other roles that we can fulfill is a conservatorship. That's someone who is appointed by the court to have the care and custody of the estate of a disabled person, someone who has been medically and legally determined as disabled, in a proceeding regarding the management of that person's financial resources, their assets, their real property, the money and other assets that they have. So a conservator is a person or entity appointed by a court with the authority to make some or all financial decisions on behalf of an individual that the court has determined needs the assistance of someone in making those decisions, and to protect the assets of that person for their own interests and well-being. Next, please. So a personal representative is someone who is appointed by either a will or by the probate court to administer the estate of someone who has passed, who has died. Chapter 473 of the Revised Statutes of Missouri explains in detail the duties of the personal representative to inventory, protect, manage, and dispose of the assets for the benefit of that person's estate. And those persons serve under the supervision of the court through something called letters of administration. That's what gives us our authority and our guide on how to administer that estate. So there's on the other things that we can do is serve as a guardian or a conservator ad litem. So a guardian ad litem is someone who is appointed by the court for particular litigation that is going on, and it is only for that litigation, so it is a limited role. And that is on behalf of that incapacitated person. And in the similar vein, it's the same thing with a conservator ad litem, is that we are appointed for specific litigation or a specific issue that is pending before the court regarding the management of someone's financial resources, of their assets, on behalf of that disabled person. So this term ad litem is Latin, and what that means specifically is for the purpose of the legal action only. So again, that is a limited role, and that ends when the legal action is completed. Next would be alternatives to guardianship, and hopefully that will be Cher Caudell. I'm hoping that she is still online.
So yes, I'm here. So it is very important to remember that there are other options before you get to guardianship. And one of those options is supported decision making. Next slide. Supported decision making can be a really good alternative to guardianship, as it allows a person to retain their right to make the decision for himself by increasing determination. Jonathan Martinez has said, while there's no one-size-fits-all model of supported decision-making, it occurs when people choose trusted friends, family members, and professionals to help them understand the situations and choices they face so that they can make their own decisions. Next slide. So there's 3 elements to supported decision-making. First, the person has the right to make the decision for themselves. Second, it acknowledges that the person can enter into an informed decision without giving up all of their rights in making the decision. And third, it's the understanding that the person may need assistance in making or communicating informed decisions through such means as an interpreter, some kind of facilitated communication, assistive technologies, or just plain language. It's also very important to remember that guardianship should always be the last resort. This is the next slide. And likewise, if a guardian is needed and needs to be appointed, the public administrator should also be the last resort. It's always better when someone close to the individual can serve as the guardian. The next slides would have been Carol's, so I'll see what I can do. I didn't prepare for this, but we'll go. Some of the other tools, there are checklists that are available, and they're designed to assist with identifying a person's ability to make their decisions and manage their key areas of life. It is also intended to assist with exploring alternatives and less restrictive options to full guardianship. And the website moguardianship.com provides the supporting information and materials. The next slide is a stoplight that was developed that helps you to identify alternatives to guardianship, and it asks just different things about like daily life, healthy living, and you answer it based on the green, yellow, or red. And then go ahead to the next slide. There's 2 pages to this. It also goes over social and spiritual, safety and security, community living, and citizenship and advocacy. And so if you land in all red, then it probably means that you're going to need at least some kind of assistance, possibly a guardianship, to help make these decisions. There's also a Charting the Life course that also is a tool that helps for exploring decision making. And so I would just encourage you to look at those. There's also, the next slide is the continuation of this tool. And it's very similar to the other one, but it would just help to determination the needs that person has. Let's go to the other alternatives to guardianship. So one of the other things that you could do instead of have a guardian is have a durable power of attorney. Now, the thing about a durable power of attorney is that needs to be completed before the person is incapacitated. Oftentimes, durable power of attorneys are used for individuals that have capacity, but then they start to, maybe as they begin to age, they recognize that there might come a time when they would not have the capacity to make those decisions. And so they would enter into a durable power of attorney. While the person still has their capacity, that could be changed at any time. You can also use a representative payee, and that person is appointed by the Social Security Division and serves as the financial manager of the money. When a conservator is appointed, they do usually become the payee for Social Security, but you can also just identify that you need assistance. You would talk with Social Security, they would help you get a rep payee. We also can use emergency guardians, and sometimes that happens when there's an emergent situation, and so the court appoints a guardian just to try to see what's going on and see if then that could be restored. Those usually last around 90 days. And oftentimes that can then, a guardian that can complete and they don't actually need a guardian. This has happened a couple times to me when someone has gone into the hospital and they've lost capacity to make decision for like a surgery or medical procedure that's necessary, but for whatever reason, they're not able to state that. And so they've appointed me so that we can get that procedure. But then once they have the procedure and they recuperate, then they regain their capacity and I'm not needed anymore. We finally can use a limited guardian or a limited conservator. And so it can be limited just to the medical decisions, like on a limited guardian, so that the person can still make their decisions of where they live, if they work, if they marry, those kind of things. There's other limitations. It's just whatever the court would decide the limitation might be. And also in limited guardianships, the ward can retain the right to vote, drive, and marry. Now we're going to turn it over to Karen.
Okay. And I also wanted to point out that the public administrators have worked very hard to make changes to the Missouri law. And actually, because of public administrator efforts, the law now says that family members are to be given first priority. They should be appointed to serve as long as they're willing and able, and that's a decision for the judge to make. And also the new law indicates that alternatives to guardianship should be looked at. So the judge may want to hear, has a family or an individual tried some of these other things that Cher talked about? You know, those might be enough to assist the person and to help them maintain the most freedom and have the least amount of restrictions on them. As far as public administrators, we always serve to be part of a team. We feel our mandate is to always seek the best interest of the individuals we are appointed to serve. We always want to have the most communication and cooperation and partnership with every person and every entity that is involved with that individual, including the individual themselves. I know in my office, we always call it a team. We're a team. It's a team effort at all times, and the person that has a guardian is part of that team. We look forward as individual public administrators, and I think it's safe to say as an association, to continuing to work with everyone. For all our clients and all the agencies, we want to work toward those individuals to have the highest degree of autonomy and the best quality of life that they can here as a citizen of this great state of Missouri. And I think we have time now. We do work with a number of agencies, and I think we kind of touched on that. But again, the public administrator is a great resource, and oftentimes we ask families, I know in our county, to call us If they think a family member might need a guardian, we say call us. We'll walk you through. Sometimes we can hook you up with the resources and services and help avoid a guardianship. And I think we have time now for questions. And I don't know if those will pop up in the chat, but I know that Carol can't be on right now, but Cher, Steve, and I are here available for questions.
As long as our connection holds. I'm not sure what's going on. I have a strong connection on my Wi-Fi, but for some reason I keep dropping.
So
Yeah.
it looks like
Yeah.
Susan
Yeah.
Spark asked a question. What if, I'm guessing that's the ward's guardian or conservator retires? I hope that's the question. And so if that's a public administrator, then the next, so there's always going to be a public administrator in office. And so the next public administrator would take over the case. If a public administrator would retire before their term ends, then the judge can appoint someone to take their place until the governor then appoints someone to take the place of the public administrator. If it's a family member, then typically you would petition the court for a successor guardian to be appointed. So like, let's say it's a mom that's been the public administrator or that's been the guardian, and she feels like she's getting older and they can't continue to serve. Then like a sibling or an aunt or anybody really could be appointed as long as they qualify. Karen, do you want to take one of the?
Yes, Sheila, I can tell you, you're talking about a medical power of attorney. The Missouri Bar has a very nice form. I'm actually an attorney and have a tiny, tiny practice. But even for people that just need a healthcare power of attorney, we refer them to the bar. So you can get on the Missouri Bar website. A lot of hospitals and facilities will have their own form, but if they don't, just go to, like I said, the Missouri Bar website, and they can send you that form. If you're here in mid-Missouri, you can call my office, and we've had people in the community stop by and pick them up. It's a very nice form, very easy to fill out, and it has all the information you have there to create a medical power of attorney.
It looks like Myron has asked what to do if you have a public administrator and aren't happy. And so I'll take it from my stance, and then I'm going to ask Karen and Steve to also weigh in on this. So in Montauk County, if you are not happy with something that I'm doing, you can write to the judge. And the judge then will usually appoint an attorney that will meet with you and then represent your interests, and then we'll go before the judge, and there will be a determination that would be made. I don't know how it works. If Karen and Steve may have some other comments about that.
Steve, do you want to weigh in?
I hope I could weigh in. I keep dropping off for some reason. I have a strong signal in my Wi-Fi, but I keep dropping off. I'm not sure what's going on. Anyway, I would echo what Cher said. Absolutely. You can write a letter to the judge and explain to them what your concern is and what you're not liking about what we do. That's the big thing, is just make your concerns and your issues known in a very clear way, and understand too that the public administrator is.
I think we lost Steve.
Yeah.
Well, one of the other things I was just going to piggyback off on what he said is the other thing that I encourage my clients to do whenever they are unhappy with the decision is we use that team approach. So I bring in people that they're comfortable with, and we kind of talk through the stuff. And so sometimes there's reasons why I have to make the decision that I do. And if I'm not able to relay that to the person to where they can understand, then I like to use their team to help me, or the team can also even present me with ideas and I will consider something different. It doesn't always mean I'll change what I'm going to do, but I'm very open to what my client wants and trying to do that and keep their best interests as well.
Right.
And I would do the same thing. I would talking to the treatment team, the service coordinators, the local SB 40 board, DDA or DDRB, depending on where you're at, working with them. And as Karen said, it's always a team approach. The other thing to understand is that, as we discussed earlier, sometimes we're going to make tough decisions and base that on what is in the best interest of the ward, what is in their best interest, not necessarily what they want. There's a reason why we have been named as a substitute decision maker.
And I do want to point out that there is always Missouri Protection and Advocacy. And, we all work well with them. They have a role and we have a role. And if you feel certain rights are being violated, you can always contact them, and they can contact us. And a lot of times they'll contact us and they say, well, that's reasonable, it makes sense. And again, I ditto what Cher and Steve say. We, in our county, we always want to have a team approach. We want to understand if the clients aren't happy, what they're not happy about. But you do have the legal right to call MOPNA and talk to one of their intake folks, and they can always follow up from there.
So Jeff has asked if we allow our consumers to attend self-advocacy groups like People First if they want to. And any of my clients that want to attend those groups that are able to, definitely. I encourage that. Sometimes it's hard for them to get to, because we live in a rural community, so there's not a People First right in our community. Sometimes the transportation is an issue, but if they want to attend, I do my best to try to make sure that they can.
And I think there's also efforts at getting broadband internet in those remote communities as well. And I'm looking forward to that increasing and improving, because then that would allow people to engage with these self-advocacy groups and other support groups via Zoom or other platforms like this one that allow people to talk and meet face to face and address those issues. No, I'm not seeing any more questions. I appreciate everybody hanging with us as we had technical difficulties, and hopefully you all got something out of all of these presentations and learned something.
Thank you all for being here today. We are sorry for the connection issues that we had for this group. Sometimes technology is great, sometimes it's not. So we thank you for your patience and sticking it out with us and getting the information to everyone today. I know they appreciate it very much.
And
Thank you very
we
much.
appreciate being able to be here to present.
Yes, we appreciate the opportunity to be able to talk to people and kind of demystify what we do and help people understand exactly what we do and why we do it.
Sure. Thank you so much.